Hi, good evening. This is Rahul Reddy from REDDY NEUMANN PC. We are here live every Tuesday giving you updates on the immigration law. Along with me is my business partner, EADD Neumann. Emily, what do you have today?
Thanks for joining today. We're going to be talking about the H-4 EAD, update on what's going on with the lawsuit, as well as regulatory process. The premium processing news that came out today for H-1Bs that are going to be filed in the fiscal year 2020 cap. We will talk about priority dates, a little bit about owning a business if you are on a non-immigrant type of visa, and of course,
the H-4 EAD.
H-4 EAD, and we'll answer your questions that you have throughout the today's live stream.
Yeah, you can post your questions to the Facebook Live or on the YouTube Live. We're checking those questions, and we'll try to answer as many as possible. And on the H-4 EAD, that's been a hot topic nowadays. What is going on the H-4 EAD? Is there any update on it? Can people file the H-4 EAD right now?
Yeah, most importantly, yes, you can continue to file, and you'll be able to continue to file even after a proposed regulation comes out. Only when there's a final regulation that actually takes effect would anything actually change. So the proposed regulation still is not out. It's still with OMB for their review as of today, so nothing new there. There is an ongoing lawsuit on the H-4 EAD that's at the appeals stage. The whole idea of the lawsuit is that the Department of Homeland Security didn't really have the authorization to give employment authorization to H-4 holders, because that's something Congress should do. Everything is now at the appeals stage. It's been pending forever. It was on hold forever. Since the Trump administration took office, they put the case on hold because we were expecting this regulation to come out. Now the case is no longer on hold, but new delays are happening. So there was a whole briefing schedule where everyone was supposed to be submitting briefs to get the ball rolling again this week, and the court just granted an extension of that, so the next round of briefs don't start to be due until April 1st instead of what was supposed to be this week. So basically, same old, nothing has happened to the H-4 EAD. It's still good, you can still file it. They're still issuing approvals for new ones as well as renewals, and just stay tuned for updates on both the regulation and what's going on with the litigation.
The only small update on the H-4 EAD is that if you're filing for H-4 right now, the filing fees has jumped up by $85, requiring you to have a biometric fees. Other than that, the H-4 EAD is good as it is, nothing has changed, so you're in good shape. Emily, priority date. This is a big question. What is a priority date in the employment-based immigration? How is it obtained, Emily?
Yeah, so a priority date is the most important date in your green card process. That's the date that determines when a green card or immigrant visa will become available for you based on your country of birth and your category, whether it's EB1, 2, 3, 4, or 5. So the priority date for most people is set when your labor certification is filed. So the date the labor certification is received by the Department of Labor is going to establish your priority date. That will be actually assigned to you when you finally file your I-140 petition and it gets approved. That's your I-140 approval notice will say what your priority date is, and that would be the date the labor certification was filed. If yours is a job that doesn't require a labor certification, like Schedule A for physical therapists or EB1 or EB2 NIW, then your priority date becomes the date your I-140 was filed.
And what are the, can you explain me, Emily, on what is porting of the priority date? And I will explain later on when it can be ported, when it cannot be ported.
So when we're referring to porting the priority date, that means retaining the priority date from an earlier filed I-140 to a later filed I-140. So anytime you have your labor certification and I-140 approved and later you file it. Maybe you change employers and have the new employer file a labor certification in I-140, or maybe you change to a higher level position where you're now able to qualify for EB2 and filing a new I-140. At the time of filing that second I-140, you can retain the priority date from your first I-140, and that's what we call porting. Basically by just submitting a copy of the earlier one. The regulations specifically say that once you've been assigned a priority date, you keep that priority date for any subsequent I-140 petition unless there was some sort of fraud or misrepresentation.
Now, the circumstances under which you can port the priority date is when you move from EB2 to EB3, EB3 to EB2, or anything. You move from EB1 to EBC, all the way EB1, EB2, EB3. Now, of course, you can't port it to EB5, which is an investor visas, but from EB2, EB3, and EB1, you can move whichever way you want it. Here is some of the conditions that if the employer has filed a petition for the I-140, the I-140 must have been approved for more than 180 days and has not been withdrawn before the 180 days or January of 2017. If both of those conditions are met, you can carry forward the priority date when you move to a different company or when you're switching from EB2 to EB3. If the I-140 has been withdrawn either before January of 2017 or it's been withdrawn after it's been approved for less than 180 days, you cannot port that priority date. So keep in mind that if ever you want to move, you have to take a decision on the 180-day golden rule, 180 days after the I-140 is approved, not after the priority date has been established, not after the I-140 has been filed. It's 180 days after the I-140 has been approved. You can port the date. That's a golden rule that you need to remember. Now, it is very important that the I-140 priority date need to be there. The availability of the priority date need to be there for you. If you were to extend the H1B beyond the 6-year limit, you need to have an I-140 that has not been withdrawn for 180 days. So for you, if you move from company A, you have an I-140 approved and it's not been withdrawn for 180 days. You can use that to move to company B, extend the H1B for beyond 6 years. From the company B, you can move to company C, company D, using the same company A's I-140 as long as it's not been withdrawn for more than 180 days. Emily, any updates on the premium processing of the H1B is for the new quota? I know it's a very big issue. We got an update recently for the premium processing that everybody can file the premium processing. Then the USCIS comes and says, wait a minute, that doesn't mean it's for the new quota. Is there any news for the quota people that are going to file the H1B in April of 2019?
Yeah, we talked about this last week that we were expecting a second announcement from USCIS about premium processing for the cap that we're getting ready to file April 1st of 2019 for the fiscal year 2020 cap. And we did actually get that announcement today. Now, what was surprisingly good news is they're actually allowing premium processing if you are requesting a change of status. So only for those petitions being filed in the lottery this April that request a change of status while you're in the U.S. from your current status to the new status of H-1B, you and your employer can choose whether to file that in premium processing right now, like in the lottery. So you don't have to wait on that. You submit your H-1B petition along with the I-907 request for premium processing and the filing fee. Now, they're not going to start the premium processing 15-day clock until May 20th, so it's going to be a little bit of delay because of all that receiving process that they have to go through and doing the actual selection. But you can actually file in premium processing if you're requesting a change of status. If you don't file it in premium processing and you decide you want to upgrade after you get selected, you can do that if you've requested a change of status anytime after May 20th. Now, if you're requesting consular processing, there's no premium processing right now. It's possible we may be able to upgrade sometime in June. There'll be another announcement for that. But for now, consular processing, where you are filing from outside the U.S., or even if you're currently in the U.S. and choosing to consular process because maybe you have a F1 status issue, or you might be traveling, for the people that are choosing to file in consular processing, you can't do premium right now.
So in other words, if you were filing from F1 to H1B right now and you're requesting a change of status, you can do the premium processing. If you're moving from H4 or L1 visas or L2 visas to H1B and you're applying for change of status, you can do the premium processing. But if you're doing consular processing, you cannot do premium processing. Emily, now the EB2 and EB3 are kind of going backward and forth. It's in 2009 priority date. It's approximately taking about 10 years for them. Though it's taking 10 years, its projection time to get the green card is more than 100 years. No hope, at least for the Indian nationals. How easy is it to get the EB1 approval for those people who are clocked up in the system? What is an EB1? What are the different categories on the EB1, and how do we obtain those EB1s?
Yeah, there's different types of EB1s. You have your EB1 extraordinary ability, where there's kind of a list of 10 different criteria, and you have to prove that you meet at least 3 of those, but also you're the cream of the crop in your particular area of expertise. You also have EB1B for outstanding researchers or professors, which has similar criteria, but specifically for those that are being sponsored by their employer for research or professor type positions. And then EB1C is for multinational executives or managers, where you've worked for your employer outside the U.S. at a branch or subsidiary or parent or affiliate company for at least 1 year, and that was in a management or executive capacity, and now they're sponsoring you for a manager or executive level position in the United States. So those are the 3 ways that you can qualify for EB1. And all of them are a pretty high bar. I mean, it's first preference for a reason, because it's meant to be for very limited number of people. And so just because, out of those 10 criteria, you meet 3 of them, that by itself is not enough. That just gets your foot in the door. Then you have to prove that overall that you have sustained national acclaim in your field of expertise. So it's not an easy process. So just comparing to the EB2 or the EB3, where you're going through the labor certification process, the only thing they're looking at there is, for EB3 skilled worker, do you have 2 years of experience? Or for EB3 professional, do you have a bachelor's degree? Or for EB2, do you have a master's degree or a bachelor's plus 5 years of experience? Those are the only requirements for EB3 or EB2. But EB1 is a lot more looking into
extraordinary ability,
what your qualifications are. So they're not easy to get. And then even EB1C, even if your position is called a manager or executive, that by itself isn't enough. They're going to be looking at where your position outside the U.S. fell within the overall hierarchy of the company, where it falls within the U.S., how many direct reports do you have, and then they're looking really at your job duties to make sure the majority of your time is spent doing managerial or executive things. So just because you're called a manager is not going to be enough to meet that EB1C requirement.
Now, discussing about the ownership of the non-immigrant visas that we want to address, we get a lot of these questions online, and we get all these questions. Now, there is a difference in the ownership of any business and working for the business. If you own the business, technically speaking you're fine to own any business. However, there is a gray line with regards to when it constitutes if you're working for that company. I for sure can tell easily If you own the stocks in the publicly traded company like Apple, Google, my favorite Tesla, if you own the stocks in that company, you are an owner of the company. Absolutely, you don't have any problem whatsoever at all owning the company. Now, if you were to own any other businesses, which is for the profit motive, obviously, I would recommend that you may want to check with an immigration lawyer if the duties that you're doing are falling into a problematic case. If you are owning the publicly traded company, the 401k, you have a stock plan, you just purchased any stocks, I can assure you, you don't have any problem because you're not working for that company. You're just owning the stocks of the company, you're the owner of the company. Anything else, we have a lot of doubt with regards to whether you're participating in the management of the company. If, for example, if you are investing in a restaurant and you are putting $50,000 as a part, as just a part ownership in the company, we have a lot of doubts about your involvement in the restaurant or any of the other kinds of businesses that is there. You may be crossing the line there, which we are very much concerned about it. These things were routinely ignored by the immigration before, but they are looking into very thoroughly. If you intend to own any of those things, I would strongly recommend that you contact an immigration lawyer. Any thoughts on that, Emily?
Yeah, you really have to think about, besides just working, you can say, oh, I don't work for the business, I just invested money, but working doesn't necessarily mean only going to the business and doing a job there. It also includes the management and the administration of the business. So you may not be working for the business, but if you're running payroll, that's working for the business. That's unauthorized employment unless you have work authorization to do that. Or maybe you're the one that takes the deposit of the payments that day to the bank. That is unauthorized employment unless you're working and you have the proper work authorization to work there. So you have to think about all those little things. Are you signing paperwork for the company? That is work, even if you're not doing a particular job. So if you're involved at all in the management, the only thing you can do when you are on a non-immigrant visa that's not sponsored by the company is be a passive investor, meaning you put your investment in and you take the profits as they come, but you don't have any involvement in the actual running of the company. That would be allowed, but it is a very fine line that you have to be careful of, especially with so many documents available publicly online that immigration officers have access to. I mean, we see time and again where they are able to look up articles of incorporation or any public
directors of the company,
Yeah.
website, email addresses that will indicate your name. There are many different ways they can find the thing out. They can always, if there is a lawsuit between you and your partner, that's definitely a good thing that they can look into to see if you were involved in the working of the company too. There are some things where the persons can do more actively, especially if you are involved in a non-profit organization. Let's say, for example, you're in a Red Cross Society. Well, let's say you are in a temple organization. Let's say you are in a language cultural organization, and you're working there, you're preparing the food. That may not be constituted as working because that's voluntary work. But if the same activity, you own the business and you are doing the work for a profit organization or you're helping out for a profit organization, that is a danger zone. In other words, you are a member of a tree planting society. You contributed to the tree planting society. You went there, worked the whole weekend out planting the trees. That may not be a violation because you're not expecting any return from there. But if you own a restaurant and you help anything out, that definitely is a problem. Emily, some questions coming up. Let's go to the questions. Here is a question that's coming out from YouTube. My employer is not willing to convert into premium processing. Is there any way I can do for myself to convert that into premium processing?
Yeah, unfortunately, the I-907 form for premium processing for an upgrade or the filing is something that the employer consent is needed for because it's their petition. So without the employer's agreement, you won't be able to file the premium processing on your own.
Srinivas has this question. His I-140 has been approved and it's not been withdrawn, and it's been more than 180 days, and his employer is threatening that if he leaves the company, he's going to withdraw the I-140. Does he need to get a new I-140 with a new company? Not necessarily. You don't need an I-140 immediately from the next company that is going to join. Even if the company withdraws the I-140, you can still use that to go to company B, and from company B, you can still use the same I-140 to go to company C. And you can port the date whenever you want to company B, company C, or company D. Your spouse can apply for the H-4 EAD based on this I-140, even if it is withdrawn. Remember, you stuck with that golden rule and you put that in the YouTube saying that it's been approved for more than 180 days. That is the one which is saving you. So you can you're free to go and join another company, and they don't need to file an immediate I-140 application.
Raj from Facebook asks if we have any update or anticipated timeline for the H-4 EAD regulation and what's going to be in it. We don't really. I mean, we've been expecting this for some time. It keeps getting delayed. It was supposed to be coming in the fall, and then they said by the end of the year. And now here we are in March, and we still don't have it. I think that we should expect the OMB to complete their review anytime now. It was submitted to them on February 22nd, I believe. And then from that point, it shouldn't take long before they actually publish the proposal. As far as how long it will take from there, I'd say a minimum of 6 months, probably longer. Remember, there's likely to be a lawsuit filed to stop the implementation of this new regulation if there's no real rhyme or reason or no reasoning behind it. As far as what's going to be in it, we do expect that it's going to completely rescind the current H-4 EAD regulation. I don't think there's any expectation that they're only going to take it away for certain people or they're limiting it or restricting it. I think their goal is to get rid of it completely. Of course, we won't know that until we have a proposal. We still don't know what they'll do with existing EADs. Our guess is that they will continue until they expire, but that is a guess. We'll have more information once we actually have a proposal.
A lot of questions on the H-4 EADs, and here is the projection why we think so that the current H-4 EADs is not going to be cancelled, and the future H-4s most probably might not be allowed to extend. Is that when Trump administration came in, they did say that for 900,000 people, they are not going to extend any more further EADs. These are the unlawful people Obama administration has given employment authorization. They're called DACA kids for the short form for you guys. So we're expecting that they will show the same courtesy for the lawful immigrants who are paying the taxes and who are here legally. That's the reason why we say that keep filing the H-4 EADs if you're eligible for. One good question that is coming up for you, Emily, from the YouTube. Pranay is asking the question. Can you update on the H1B fiscal year 2020 statistics of the H1B? What he meant is that the H1Bs that are going to be filed in the first week of April of 2019 for the quota of the fiscal year 2020. Can you project how many applications are going to be filed, and what are the probabilities for the master's people to get it? What are the probabilities for the bachelor's people to get it?
Yeah, so this year I think is a little more difficult to predict because normally when the unemployment rate is super low, we see an increase in H-1B filings as companies have to look elsewhere to fill their open positions. But at the same time, we have the Buy American, Hire American executive order, all of these immigration policies that the Trump administration has been limiting legal immigration, making it more difficult, more RFEs, 60% RFE rate now, lots of denials that were never seen before. And so there's a lot of employers I think are much more hesitant to file this year than before, even if unemployment is so low. Again, this is totally a guess based on kind of just what we're seeing, based on the filings we're doing. So
coming to the point, Emily. Coming to the point, Emily. What's the chance? How many applicants in the master's quota are going to be filed?
Well, I didn't go that deep into it, but I think an overall, I think we'll see maybe less than 180,000 this year.
The total, including bachelor's and master's.
Yeah, I'm thinking it could go as low as 150. As far as chances of selection with this modified selection process, I looked through the numbers from the last 5 years that USCIS gave us about how many master's cap cases, how many bachelor's cap cases are filed each year, how many are not selected in the lottery. So based on all of that and the change in how they're going to do the lottery this year, I think master's cap applicants should have about a 75% chance of being selected this year.
So your projection is 75% chance for the projection for the master's quota people, and maybe 25% for the bachelor's?
I think it's going to be higher than that, maybe 40, 50%.
Okay.
Obviously,
for the bachelor's quota people.
Yeah, I think
that's Emily's. And for those people, who, please, you can check her blog at immigrationgirl.com. Once the application has been filed, she keeps the statistics. How many H-1Bs are already selected, how many H-1Bs to be yet selected. So people are curious. That is my friend got a receipt notice, I didn't get a receipt notice. What are my probabilities? Emily writes a blog at immigrationgirl.com, and she updates it every day, saying that these many number of master's quota people were supposed to get selected, but we only received these many receipt notices. So here is the possibilities of your H-1B to be get selected in the master's quota. Here is a possibility of you still getting selected in the bachelor's quota. Please subscribe to immigrationgirl.com. That's Emily's blog. Many questions on the I-140, H-4 EAD, lots of questions, Emily, from the YouTube. One of the I-140 question that I got from the YouTube is, if the employer goes out of business, will it cause any problem for the I-140? No, that doesn't cause any problem for a I-140. The golden day 180 rule is still met. You don't have a problem if they go out of business. When it causes problem is if the I-140 has been withdrawn before 180 days, or if the I-140 has been revoked for any fraud committed by the employer. But if the employer goes out of business, that should not cause any problem for you.
Question on the H-4 EAD. If the H-1B extension is already in progress, can the EAD application be submitted? So I think in this situation, both the H-1B and H-4 extensions have been filed, and now they want to file the EAD. So USCIS guidance says that if you are filing your EAD separately from the H-4, you've already submitted your H-4, they prefer to have the H-4 approved before you submit the EAD. And I think that's probably a smart way to do it, because when you've got the H-1B and the H-4 filed together, now you're dealing with H-1B processing times, not H-4 processing times, which can be much longer. So you want the H-4 to be approved quickly with the H-1B, and then you can turn around right away to file the EAD. I think if you submit the EAD based on the pending H-4, you're likely to cause extra delay on your EAD, because you might get a request for evidence asking for that H-4 approval after you've been waiting so long, and that's going to add another 60 days of delay.
One question from Sandeep is that if he applies for EB1 and tries to port the date from EB2 to EB1, and if his EB1 gets rejected, what happens to the EB2 I-140 approval? Is EB2 I-140 approval will stay as it is. It is not denied. You can use it. You can get the green card through that when the prior date becomes current, or you can further port it to a different company, or you can try the EB1 again. It remains with you as long as, remember the golden rule I told you, 180 days that the I-140 has been approved.
Annie has a question on Facebook. Currently on H1B and filing a change of status to H4 with the EAD. Wants to know what happens if the H4 gets approved but the EAD is still pending. Can you continue to work on the H1B? And the answer is no. Once the H4 is approved, you're now in H4 status from that date. And you can't work until the EAD is issued. Now the good news is it's been pretty rare that the EAD gets delayed beyond the H4 approval. We don't see that happen very often unless something was missed out in the EAD application or rare circumstances, but most of the time they are approved together, so you wouldn't really end up in that situation.
So the question that comes out is that his wife is working on H4 EAD. She used to have an H1B before. I'm assuming that she hasn't used up the 6 years of the H1B. If the EAD has been cancelled, can she move back to H1B without subject to the cap? Yes, she can move back to the H1B without subject to the cap if she had ever had a H1B. When I'm saying she ever had a H1B, I meant to say that she worked on H1B on an I-94 or she had a H1B stamping done in her passport. Either of those things will meet the requirements that the person was on H1B. You can always move back to H1B without subject to cap if you have not used up the 6-year limit. If you have used up the 6-year limit, you can right now apply for an I-140 application, and if it's I-140 has been approved, you can still move back to H1B even if you have used up the 6 years.
Robbie has a question on Facebook. He's got an H1B still pending from last year's cap. Can he file again in this year with the same employer? Yes, you can. There is a restriction on the same employer filing for the same employee, but that's in the same cap year. So if you are filing in a different cap year, we haven't had any issues with that. Now there's a little bit more facts to his situation where last year's H-1B was filed for an in-house project. The same company this year all of a sudden has a client project that they want to file. Do you think that is going to be an issue?
I want the in-house project to be withdrawn, Emily. I know what this in-house project is. Guys, don't fall into the trap of the in-house projects. We're having a lot of these H-1Bs that have been filed for in-house. Now, when I mean to say in-house is the consulting companies that are filing for in-house thing for a future projects and which most of them don't materialize. Be careful. I don't want you guys to file a H-1B with those things. If you filed a H-1B, please withdraw it. Try to file with the end client right now. What we have noticed is that the USCIS is going back to 2015 and 2016, and they are revoking all the H-1Bs that are approved for the so-called in-house. What happens with those revocations is that even if you're not working with that company, even if you have moved to a different end client, even if you have got an extension, since the first H-1B is not a proper H-1B, all subsequent H-1Bs will be revoked. So you'll be out of status, then you'll have to leave the home country. That's the reason don't trust these companies that are filing in in-house projects when they are projecting into you guys know what I mean by in-house. I mean, I don't want to spill it out in this YouTube.
All right, and yeah, and if you have that first H-1B revoked, now you're subject to the cap because it never should have been granted in the first place. So you lose a lot by doing that.
One problem is they're out of status for all these 4 years.
Yeah, a question on Facebook. Perm application was filed while he was in the 6th year of H-1B. Now he's on H-4 EAD and wants to switch back to H-1B. Does he have to wait 365 days? Or if the I-140 is already approved, can he switch back earlier? So once you have the I-140 approved, the 365-day rule is gone. You don't need to wait 365 days. An approved I-140 allows you to switch back to H-1B status and extend beyond the 6th year for up to 3 years, even if you got it within less than 365 days.
One question that came in YouTube, Emily, is that the future employer adjustment of status interview, what documents are required? He's asking the question that he has filed an employment-based adjustment of status which is not working for that company based on the I-140 filed for the company. All you need is a J supplement. If you have not filed a J supplement along with the 485 application, you would require a J supplement. It's called 485J supplement. For all those applications that were filed before March of 2017, if USCIS have already issued RFEs for those people to submit the J supplement. If they have not issued it, I would recommend that you take the J supplement. If you have all filed an adjustment of status on or after March of 2017, you have already submitted the J supplement. You don't need to submit again. I would take a copy of the J supplement along to the interview. I would also get a fresh dated employment letter indicating that the job is there for you. In the YouTube, Emily, he did mention that the employer is not in the same state as where he is living it. That is not going to be a major issue though. If it is a consulting company, that's not a major issue at all. If it's not a consulting company, you could, if your intention is to move to that state once you get the green card, and if the employer's intention is to hire you once you get the green card, just because you're not in the state should not be a reason for denial of your adjustment of status.
Question from Facebook is, how is the new biometric requirement for I-539s going to impact H-4 processing and H-4 EAD processing, especially when we're talking about premium processing? So we don't have any real world answers on that yet because we have not started submitting the new I-539 form. That starts from March 21st this week. What we do know is USCIS had hosted a stakeholder call, and they let us know that typically from the time an application is received till the time the biometrics process is complete, it adds about 17 days on average to the process. That's assuming you don't have to reschedule your biometrics appointment. So they generally will issue the appointment relatively quickly after you file, giving you about a 7-day advance notice. You go get the biometrics done. That gets updated right away to USCIS, and then they continue the process. So for regular processing applications, I don't think the biometric will add too much of an additional delay to the processing time unless you have to reschedule your appointment. But for premium processing, obviously if we're talking about adding 17 days, there's no way they can complete it within the 15-day premium processing clock. So what they told us was that they will adjudicate the H1 within the 15-day clock. They'll do the biometrics generally within the 17-day clock, and once those are back, they will adjudicate the H4 and if there's an EAD as soon as possible, trying to honor the premium processing. So you won't have the 15-day requirement, but they did say they will try their best to honor the premium processing timeframes as soon as those biometrics come back. Of course, we'll see how that really plays out in practice. One thing that we're considering is possibly filing everything in regular processing and then waiting for the biometrics to be done and then upgrading to premium. Now, that's not something that USCIS has guided us on or said how they'll process those situations, but that's just one option we're considering as a way to try to limit the amount of time it takes to get the H4 and EAD approvals due to this biometric requirement.
You have this question from YouTube that his H1B I-94 with company A has expired. However, he has filed a transfer with company B and that transfer is still pending. Can he file one more transfer to company C? Here's the issue. Because your I-94 with company A has expired, your company B's application, we consider that as a bridge application. Now, if you apply for the company C, the USCIS Immigration Service will tell that they want to wait until what happens with the company B's H1B. So your company's C's H1B application most probably will not be approved with the I-94. I would recommend that you wait for the decision with the company B, and after you get that decision, you apply the transfer with company C. Another question that came out here is somebody in YouTube wants to explain what is the 60-day rule grace period. Is it only applicable when you are being laid off, or is it applicable when you resign? The regulations stipulate that when you lose the job, they don't say whether you lose it because you resign it. They don't say that you lose it because you have been laid off. So as of now, we have not seen any interpretation otherwise by the USA. So in your case, even if you resign the job, the 60-day grace period is still applicable to you to go and join another company and file a transfer application for you.
So Rob is on H-4 EAD and received the I-140 approval, wanting to switch to H-1B, who's never held H-1B before, and wants to know if the I-140 means that you don't have to go through the lottery, or if you've been counted towards the cap. So what the I-140 approval does is allow you to extend beyond the 6-year limit of H-1B, but you still are subject to the cap if you've never held an H-1B before. So the I-140 does not make you cap exempt, it just allows you to extend beyond 6 years if you've already filed in the cap.
Prabhu has this question: is it advisable to join the big 4 consulting companies? Do you have any percentages of denials for these consulting companies? He's speaking of big 4 consulting companies. He did name 2 of the consulting companies here. I don't want to name them. Here is my advice, Prabhu. It's very dangerous to join these companies. Sorry to say that. It's the percentages of denials for these big consulting companies seems to be higher than that of the smaller consulting companies. I would recommend, Prabhu, if you get an option, I would recommend to join an end client directly. The denials that we are noticing are coming more for consulting companies that are placing individuals at the third-party location. When you look into the statistics that have been released recently by the USCIS, it's clear on the face of the denials, the percentage of the denials are more when companies are placing them at a third-party location. So Prabhu, if given an option, if I were you, I would try to look for a job which gets me to the end client rather than to the consulting company.
Alan has a question about bridge petition. So he's filed his extension, and while the extension is pending, the I-94 expired, so now he's in what's called a period of authorized stay, and wants to know what happens if that extension ends up getting denied. So the denial at a time when your I-94 has already expired means that the day following the decision, you start accruing unlawful presence, and the day following the decision, you are no longer in status, you're out of status. Now, does that mean you have to leave the day you see the decision on the USCIS website before you've even received anything in the mail? Obviously I can't recommend to someone to stay in this country without status and unlawfully present. However, we do know from the NTA memo, the notice to appear, that in the event that USCIS denies an extension and the I-94 is expired, they won't issue an NTA until the 30-day period for the appeal has gone through. So now, right now, that NTA memo only is applied to 485s and I-539s and a couple of others. They're not applied to I-129 petitions. However, again, I can't say that you can stay, you're not legally in this country, but a reasonable period of time for you to receive that denial, make your travel plans, and exit should be acceptable as long as it's not exceeding that 30 days. And that's even if you're planning to file an appeal and you do decide to exit, you can still file an appeal of the denial of that petition, even if you decide to leave the country.
Abhishek from YouTube has this question. He is he has already has a EB1 approved. His priority date is not current. It's only been 2 years that he's been on L1A. Is it advisable to file under the H1B lottery system? Man, oh man, Abhishek, you have the best company to work for. They have filed for his I-140 within 2 years, and he has already have an I-140 approved without the premium processing. He already have the I-140 approval. Yes, it's advisable probably to apply for the H1B under the quota. You have a good company that you're working with. We don't see normally these L1A people coming into the United States. Those companies don't file for the EB1C as soon as they come in. Yes, it's advisable for you to apply for the lottery system because we don't know how long it's going to take for the priority date to become current. You may choose to have the H1 approval and then move back to L1A if you want to. In that way, you have the option of moving back to H1B at any point of time.
Rajasekar has a kind of a follow-up question to our discussion of an I-140 that's been approved for 180 days and then later withdrawn. He wants to know, so does the new company ever have to file a new I-140? And so there's the I-140 serves several purposes. The main purpose of the I-140 is for you to actually get the green card.
Maybe no longer anyway, Emily.
At some point. But it also allows you to get those extensions beyond the 6-year limit, allows your spouse to get the H-4 EAD. So for purposes of extensions of the H-1B beyond the 6-year limit and the H-4 EAD, no, you never have to get a new I-140 with your new employer until your priority date is actually current, because then you're limited in the ability to get those extensions. But for you to actually get the green card, at some point, a new employer has to file to get you a new I-140 so that you can actually file your 485. So it's not, in the short term, it may not be necessary for you to get that new I-140, but in the long term, you have to have it in order to actually get
Eventually,
your green card.
you need to have it, but based on. Follow-up question from Mr. Konda Reddy from YouTube, Emily, is that he's asking, his I-140 has been approved. He wants to leave the country and go to India. I'm assuming that, Mr. Konda Reddy, that you have your I-140 approved for more than 180 days. And he wants to leave to his home country, India, and want to stay there for 2 years and apply the H-1B under the new quota. And if it gets selected in the lottery, can he come back and use that priority date to port into this new company? The answer to your question, Mr. Konda Reddy, is that yes, you can. But there's one other little trick that you need to know. You don't need to apply in the quota ever. If you have an I-140 approved, it's not been withdrawn for 180 days, you go to India, you want to apply for the H-1B, you are not subject to cap. You can apply the H-1B without subject to cap, and you can come into the country and then port the date for the I-140 eventually.
All right, Sachin has a question. If an amended petition is pending with a current employer and you file a transfer and join the new employer, is there a problem with doing that, and what if the amendment gets denied? Is that going to impact the transfer? So generally, no. I mean, the amendment is to allow you to work under the new terms and conditions that are mentioned in the amendment while it's pending. And then if you transfer to a new employer, at that point, you don't need the amendment anymore. It can be withdrawn and it has no impact on your work with the new employer.
CSPA, can you please update this one? What is aging out? Rashmi has this question from YouTube. Child Services Protective Act is what she's speaking about. These are the things that protects, that freezes the age of the kids. Now, Child Services Protective Act is not that useful in the employment-based immigrants, especially if you are born in India. Here is the reason though. The age of the kid who is becoming 21 is only frozen for a period of time where your I-140 is pending. So for example, when you file the labor certification, that time period is not frozen. when you file the I-140, that time period is frozen. So if your kid is becoming 21 years old and your priority date is about to come, the time that is taken off from the 21-year period is the I-140 period. However, though, if you are able to file the adjustment of status, even if the kid ages out, becomes more than 21, you can still continue for the adjustment of status, and the kid will still get the green card. So you have to be very careful when you're looking into the Child Service Protective Act, at what time the kid's age is frozen, at what time you can file the adjustment of status. Now, the freezing of the age of the kid is not applicable for the H-4 visa. It's not applicable for any other non-immigrant visas. So if your kid is becoming 21 and they are an H-4 visa, their age does not freeze. They will go out of status on the day they become 21. So you need to apply other non-immigrant visas, most probably the F1 visas, way earlier. One of the reasons why we tell way earlier is that it's taking approximately 12 months to 18 months to get the F1 student visa approved. And the kid has to maintain the legal status until he gets the F1 approved. And the problem is, once he turns 21, he's going to be out of status. That's why the F1 will be denied. So you may want to calculate properly when to file for the H4 to H1 for your kid. Now, normally we recommend 2 years in advance to file for the F1, not 6 months, but 2 years in advance. Any other comments on the Child Protective Services Act, Emily?
No, I think you pretty much covered it there. Karthik has a question about someone who is a citizen of one country but born in another country.
Whoa!
So it's a good question. His is particularly for Singapore, because Singapore has a special H-1B called the H-1B1. It has a separate cap, and usually that cap, I don't think it's ever been reached, so they're always available. But this person is a citizen of Singapore but was born in India. So yes, they can still qualify for that special H-1B1 for Singapore citizens, even if you're born in a different country. So for non-immigrant visas like the TN for Canada and Mexico, the E3 for Australia, the H-1B1 for Singapore and Chile, it is your citizenship that counts. Only for the green card process, that's where they look at your country of birth. So yes, if you acquire another country's citizenship, you can take advantage of whatever visas are available for those countries, specifically the E3 for Australian citizens, the TN for Canadian and Mexican citizens, and the H-1B1 for Singapore and Chile.
Hari has this question that his wife got H1 to H4 conversion approved, but the original notice has not been received. Can his wife go and apply for the H4 visa without the original approval? Yes, it's not that important to have the H4 approval. You need to have the H1 approval with you. If the H4 courtesy copy plus your H1 original approval will do the trick in getting the H4 stamping done in your home country.
Archana wants to know about the approval, I guess, chances for a sales engineer position. I'm assuming this is for an H-1B. It's not impossible, but definitely expect a request for evidence on whether the position qualifies as a specialty occupation, because it's not clear that all of those positions require a bachelor's degree for one, and then there are many different fields that you can use to qualify to become a sales engineer depending on what it is you're selling. And so that makes it questionable also whether it's a specialty occupation. So really it's going to depend on the wage level, the detailed job duties, and all of that. But I would just be prepared for a request for evidence with that.
Well, it may be worth for them to sit down with the HR and the immigration lawyer. I mean, what is sales engineer? Is it like something that they're selling civil engineering stuff? Is it a mechanical engineering stuff? Is it they're selling legal books, or they're selling the lease? And normally, sales engineers are what our knowledge comes in is that they are selling something specific, like an industrial equipment, the mechanical stuff. So if they are doing it, what are the kind of skill levels that are used? When you look into the job description, when we speak with the sales engineers, we tell when you go to the customers, what do you explain? When you speak with the customers, what do you explain? They tell that the pipe and the length of the pipe, how it's broken, how they test that in the company to do all those things. It looks a little more like an industrial engineer or mechanical engineering to me. So you may want to discuss with an immigration lawyer to see if it qualifies any different title than the sales engineer. You might have a better chance of getting the H-1B approval.
A question on the biometrics fee. We talk a lot about H-4 and H-4 EAD and having to pay this new fee. I just want to make it clear that the biometrics fee is only required for the I-539. That's for the H-4. The I-765 for the H-4 EAD does not have a biometric fee requirement. So just to clear that up for a couple of people that had questions there.
Harun has this question for me particularly when I said, well, you don't need, no green card for I-140. You don't need, here, why do you not need I-140 to get the green card? The reason why I commented is that the waiting period for getting the I-140 through I-140 green card for Indian nationals seems to be somewhere depending on which professional that you're going to ask. Those people who have studied the numbers and have looked into the Department of Labor, looked into the I-140 and USCIS published records, will stand between 100 to 150 years. That's the reason why we think so that, unless there is something changed, the I-140 may not be good enough to get the green card because we expect a lot of people to die between less than 100 years to 150 years from now. That's the reason why I-140. But I-140 can still be used for doing the H-4 EAD extension and H-1B extension and putting the dates to the new employer.
One last question, I guess, from Pooja. Her husband is on L1, she's on L2. His employer is filing an H-1B in the cap this year, and she wants to travel while it's in process. Are there any issues with that? Generally, no. The L2 should be able to travel. Now, of course, if you're filing your L2 to H4 change of status along with it, and then you travel, yeah, that's going to abandon your change of status request. But if it's only the H1 that's being filed for your spouse, who's maintaining L2 status while it's pending, and you go out and come in on L2, no issues there. Just make sure that by the time the H-1B is being adjudicated, if he's requested a change of status, you need to make sure that your change of status has been filed. And then if he's going to be traveling, then probably consular processing is what you need to consider, because if he travels while it's pending, the change of status portion will be automatically abandoned.
Well, thank you guys for coming and tuning in to Reddy Neumann PC's 5 p.m. Central Time every week on Tuesday. If anybody, if we could not get to your questions, you can attend our daily conference calls. You can check the daily conference call details at rnlawgroup.com. You can subscribe to our news at RN Law Group or the blog at immigrationgirl.com. You can also make an appointment with me, Emily, or any of our colleagues, and our schedule